Nadia Bernaz from the University of Wageningen, and also Federica Muscaritoli from the University of Copenhagen. First, we will start with Nadia. Nadia, as I said, is associate professor at the Law Group, the Wageningen University and Research, and she's also the leader of the Business and Human Rights and Environment research line. She holds a PhD from the University of Aix-Marseille in France, and she has a strong international law expertise and has delivered training to companies, government, civil society around the world. The event is going to be recorded, so for the people online, if you prefer, you can turn your camera off as you prefer. And I give the floor to Nadia, who is gonna talk to us about the international implication of the Corporate Sustainability Due Diligence Directive. Thanks. Go ahead, Nadia.
Thank you so much. I think you can hear me. Yes. Thank you, Chiara. Thank you for the invitation. I'm really happy to be here in Bergen for the first time. It's not my first time in Norway, but it's my first time in Bergen, and it looks really nice. I like the offices with the sea view. This is fantastic. So today I will be talking to you about this topic, the international implications of the EU Corporate Sustainability Due Diligence Directive. And this is not working. Hold on. Yeah. Okay. So this is what I will cover in this presentation. First, I want to give you a little bit of an indication as to where we are with this directive that perhaps not everybody has heard about. So I will give you a bit of context and where we are with this process. I will then cover also relatively briefly the contents, who does what, how, as I like to present it with regards to this directive. And then I want to focus on the core aspect of this presentation, which is what interests me the most as an international law person trying to get into EU law. What are the international implications of the adoption of this directive? Focusing on these three aspects. First of all, is that an example of exporting EU values to the rest of the world? What can we expect in terms of Brussels effect of the directive? What will be the implications on companies and governments around the world? And also, what does that mean for the Business and Human Rights Treaty, a parallel process of lawmaking in business and human rights happening at the United Nations? So these are the three core aspects of the presentation, three implications that I see and would like to discuss. But of course, I'd be happy also to hear your thoughts. So let me start with a little bit of a recap about this directive, towards the directive. So let me start with explaining what is due diligence legislation. So when we talk about due diligence legislation in the business and human rights context, we mean legislation broadly. We mean this, we mean legislation that requires large companies to identify and address their negative human rights and environmental impacts. So the basic idea is very simple. You're a company, you have to know what your impacts are in terms of human rights and environment, and due diligence legislation is there to force you to do that, essentially. And this concept of human rights due diligence is embedded in the UN Guiding Principles on Business and Human Rights, adopted in 2011. This is the document, the international instrument that coined the term human rights due diligence. Of course, those of you perhaps doing corporate law will be familiar with the term due diligence in the context of corporate law. Normally, it is meant the term due diligence is normally used in the context of mergers and acquisitions, where if you're an acquiring company, you will check that the company you're acquiring, you're doing your due diligence to check they don't have some bad debt or liability lying around that you'll get responsible for if you buy them. So it's this sort of idea of taking care and making sure that paying attention at what you're doing, exercising due diligence to make sure that you're not putting yourself in trouble. So the genius, so to speak, of the guiding principles is to have used this concept, which is very well known in the corporate law or corporate governance field, and to add human rights in front of it to sort of convey the idea that this is something you already do, you just have to do it in the human rights context. So all the legislation that we've seen developing since the 2011 is all vaguely inspired by this instrument, the UN Guiding Principles on Business and Human Rights. So in Europe, we've seen developments on this with certain countries that have adopted what can be called human rights due diligence, and Norway is one of them. France was the first one. Germany also adopted a law, and then you have various color codes here that signify that either there's a political process going on or that at least there's some civil society talks about it, which of course can mean various things. It can mean there was one workshop organized 3 years ago and nothing else happened, or it can mean there's actually a coalition of people talking about this. This is not also the most up-to-date map. I think this map's about 6 months old. I think in the UK, they've made progress since then, to the point that maybe we may be able to talk about political process now. But essentially, this is to give you an idea that these discussions are basically happening across Europe, with some countries that have already legislated, both in the EU and outside the EU, like Norway. So the context of the directive is that it's one of many initiatives. I think there's a lot of people in this university who focus on issues that connect to, let's say, sustainability law broadly. And so I want to share this because my go-to report, when I try to remind myself of all the initiatives that exist in this area, my go-to report is this report by the Danish Institute for Human Rights. It's very often updated, and they just keep track of all the legislation, broadly speaking, touching upon business, human rights, and the environment in the EU. So the directive, of course, I'll be focusing on the directive only, but it's part, I think it's nice to realize that it's part of other regulatory initiatives that are connected to business, human rights, and the environment. And here I'm talking about things like import control measures around forced labor, the deforestation regulation, reporting directive, the taxonomy, etc. So perhaps some of you work on that. So it is really to be seen in this broader, let's say, ecosystem of law of legislation coming from the EU. But of course, today I'm focusing only on the new directive. So the rationale for this directive is harmonizing. If you Google photo harmonizing, that's the photo that comes up, which I thought was beautiful, though not entirely clear, but I just thought I'll just put it there. So the reason why the EU took over this project, this directive project, is because, as you saw in the map that I showed earlier, many EU countries and also EEA countries like Norway have decided to start legislating on this issue. And what the European Commission hates more than anything else is when different countries do different things. So there was this real urge to harmonize and to make sure that, let's say, the internal market is not disrupted and that you don't have countries going about doing their own thing, potentially disturbing the market, the internal market. So that was the rationale. And the kickoff, let's say, I think we could debate this, but for me, I'd like to make it start during the Finnish presidency of the EU in 2019, where they really pushed this agenda, and recognizing that we now have a fragmented landscape. I think it's worse now than it was in 2019, but I think this reasoning still holds. There was really a need, in light of all these countries starting to do their own thing on this area, there was really a need to harmonize and to get So that's why we have it. And so this is a tentative timeline of where we are and what happened. So in February 2022, the Commission issued a proposal. That was, I mean, there's many steps before. They did a big study. They interviewed a lot of people, academics, businesses, governments. And eventually they put all this together and they came up with this proposal in February 2022, followed in December by the Council of the European Union, also adopted its views on the directive. That was called the General Approach. And then Parliament in June 2023, the EU Parliament adopted its position, and that started the trilogue period where the Council, the Commission, and Parliament talk with each other and try to find some kind of agreement. This lasted way longer than it should have, but eventually in March, so like 2 weeks ago, 4 weeks ago now, the Council of the European Union adopted a version of the directive. So we are here, like you can see on this slide. We're now waiting for the adoption by the European Parliament. This is scheduled to happen on the 24th of April. I can confidently speak about that because it looks like it will go through without lots of issues. So yeah, I'm expecting that it will happen. And then we'll start the usual process whereby countries will have 2 years to transpose. And then from 2026 onwards, we will move towards implementation. So we're still, in some way, it feels like it's been forever for people like me who've been following this. On the other hand, objectively, we still have a long way to go before this makes any kind of impact. And before anything I'm going to talk about now actually materializes in countries that don't have legislation yet, which is the vast majority of EU countries. But so with a bit perspective today, let's just say. Right. So I want to give you a few indications about the content of the directive. So who does it cover, to do what, and how they're supposed to do it, just so that we're all on the same page. So some key elements. First of all, which companies fall under the scope of the directive? We're talking about very large EU companies and very large non-EU companies doing business in the EU. And when I say very large, I mean companies that have an annual turnover of over 450 million euro. That's very big, very large companies. I don't want to explain all the details of the negotiation, but it wasn't always like that. This is a last-minute change from the Council. When I said it adopted the directive in March, it did adopt the directive in March, but at a price of significantly reducing the scope. Originally, it was supposed to be a much lower threshold than that, to the point that there's now NGOs within Europe that have made calculations, and they estimate that about 5,500 companies EU-wide will fall under direct purview of the directive, which is very few given the size of the European market. Secondly, so that's for the scope. Secondly, in terms of, sorry, that's for which companies? Hello, whoever you are, can you mute yourself? Okay. Yeah, so in terms of what these companies are supposed to do, they're supposed to exercise due diligence, that is, have a process in place to identify their human rights impacts and address those impacts in their own operations and the operations of their subsidiaries and the operations of its business partners in its so-called chain of activities. I'm putting this between quotation marks here, because that's another term that didn't exist until March and that was added by the Council during the last-minute negotiations. It used to say business partners, direct business partners, or direct business relationships, excuse me. So this chain of activities ideas was just added really recently, like as in a month ago. And so what is meant by this chain of activities is the company's upstream value chain. And in terms of downstream, some downstream activities, but not all of them. So for example, from memory now, I think it includes transportation, but not waste management. Yes, thank you. So again, that's a change because it used to be the whole value chain. And now, of course, by removing some of it, of course, it makes it, in theory, easier for companies to comply. Though I think this needs to be seen when at implementation phase. I'm actually not, I mean, I think we need to see how this will work in practice. On paper, it looks like a big change, but we'll see. So in terms of what is human rights and what is the environment for the purpose of the directive lists, so talks about adverse environmental impacts and lists relevant provisions of certain conventions in the annex. Interestingly, the Paris Agreement is not one of those conventions. What we have instead is a different provision on climate in Article 15 of the directive that asks companies to have in place some kind of climate plan, but the obligation to conduct due diligence that is to address the climate impacts of the companies, that's not included in the due diligence process, which of course is a massive difference from if had it been included, that would open the door to a lot of or to really strong obligations climate-wise. The fact that it is out is, in my opinion, a big issue with the directive. Now you can see the glass half full and say there is a specific article on climate, so it's not completely forgotten, but the obligation is much lower, much, like really much different from the due diligence one. In terms of human rights, it's a really odd decision that was made here, and I haven't fully, to be honest, fully understood the logic there. They have listed some rights and also some conventions, and it's just really hard to understand why they have listed some rights and not others, why some conventions and not others. That being said, I want to be too critical because I read the list and I couldn't really see anything that was glaringly missing. I would say, as a human rights lawyer, like I really looked at that list and couldn't see anything where I thought, okay, this is really missing. So I'm not sure what the logic was there. I would have just referred to the European Social Charter and the European Convention on Human Rights and leave it at that, but they decided to go right by right for some reason, I don't know. So maybe some people know, or in the online as well. But in any case, although I would say on environment, the fact that there's no Paris Agreement is a big gap. I would say on human rights, it's pretty, to me, it looks really comprehensive. Like I don't see any real issue with that. Okay, so the obligations, this is the last slide with that much text, I promise, but just to explain what the directive is about. So Article 4 talks about the obligations that will fall onto these companies. So similar language to the UN guiding principles, though not exactly the same. Companies need to identify, prevent, mitigate, bring to an end adverse human rights and environmental impacts, like I said, arising from their own operations, the operations of their subsidiaries and business partners in the chain of activities as defined. Yeah, so some upstream, some downstream or upstream. So that's the core obligation. Identify the impact, prevent the impact, mitigate, bring to an end. So that's the core, if you will, of the obligation. What I find really interesting personally is the compliance mechanism, and particularly the fact that the directive talks about national supervisory authorities that will have to be created to ensure that the directive is properly implemented by the companies that it should apply to. This is going to be very interesting. This is new. None of the countries that have due diligence legislation have that with that much power. They're supposed to have inquiry power. They're supposed to be able to investigate. How is that going to work? And particularly, how is that going to work for foreign companies that fall within the purview of the directive? I don't know. I don't know if people have thought about that, but we'll see how it works in practice. This is real added value because we don't have that. And of course, it's always better to prevent than to go to court to solve issues that may have arisen. So yeah, and they will have also the power to give sanctions. Again, what does that mean? How much money are we talking about? I don't know. I think there will be a lot to discuss at the implementation, at the transposition phase. And then finally, we do have liability provisions as well. And there, the bar is set quite high for liability to arise. You need to have a negligent or intentional failure to comply with the obligation to prevent or to end the harm, and a real causation between failure and damage. There's no reversal of the burden of the proof. It is for claimant to prove that. And we know from experience of civil litigation in business and human rights that this causation is very, very difficult to establish. I really do not expect any floodgates of cases coming out of this. This is very conservative language. So I'm not a civil lawyer, so I don't get too excited about this. Personally, the national supervisory authorities, as a public law person and trained in administrative law, this is more interesting to me. Maybe others also online will have different reading, but just to say, the novelty is definitely not in the liability provisions, that's for sure. So, yes, I have time. So now I want to talk about what does that mean for the rest of the world, this directive. So first of all, I think I want to address this issue that I've seen come up quite a lot now recently around exporting EU values. Is the EU exporting its values by adopting a directive that purports to regulate activities overseas, impact that can happen outside the European Union? So first of all, I think it's really clear that this directive has an extraterritorial reach. First of all, it applies to large foreign companies. Like I said, if they have a certain amount of business in the EU, they will fall under the law. That you can say, okay, they do business in the EU, so that's not really extraterritorial, but nevertheless, they are foreign companies. But what I find more interesting is that the directive will impact smaller companies that are in this chain of activities of those large companies that fall within the scope of the law. So it's clear that the idea there is that this will have an impact outside of the companies that fall within the scope, that they will somehow have to influence what other smaller companies are doing outside the European Union. So although the term extraterritorial is not, of course, not mentioned in the directive itself, it has this feel like it will, by necessity, have this those implications. And so I would say that this directive is an example of what Professor Ruggie, the father of the UN Guiding Principles on Business and Human Rights, called a measure with extraterritorial implication. Yeah, so this is a clear example of that. It's not clearly said, but it's obvious that the goal is to influence what will happen within the chain of activities, and therefore outside the European Union. So I'm actually a big, I'm really interested in this particular issue. I've published on this before. There's a history and also lots of literature on this kind of legislation that somehow purports to influence what's happening outside the country in which the legislation was taken. So I give a few examples here. In the United States, we have legislation in the 1970s that aimed to not import products coming from communist countries on human rights grounds. Also language like that was used. We have anti-apartheid legislation in 1980s, also aiming to somehow influence what companies were doing outside the United States. And also in the 1990s, there's a famous, I don't know if it's famous, but there's a case at the Supreme Court of the US regarding legislation on Myanmar, on procurement, actually taken by the Massachusetts states, which also aimed to somehow influence the conduct of business activities abroad. So although the directive is a bit different, there is this idea that as the European Union, you can adopt legislation that somehow seeks to influence human rights and environmental situations outside the EU. So the reference to EU values, we find it in the very first paragraph of the preamble of the directive. And if you read that provision, it talks about how EU values and the universality of human rights should guide the Union's action on the international scene, which includes fostering the sustainable economic, social, and environmental development of developing countries. First paragraph, second sentence of the whole text. All right, so it's clear that this is the goal. This is why this is adopted. This is to foster sustainable economic, social, and environmental development in developing countries. So what is not said here, of course, always interesting to say what's not said, is that implicitly we're saying the human rights issues, the environmental issues, they're outside the European Union, and we're now legislating to deal with those issues. That really is, the message, I think, that is being sent with the directive. And it's really clear from the very first paragraph. Like I said, clear goals, ensuring rights protection, economic development in third countries. So what do we do with this? What does that mean? I think it's fair to say there's a lot of debates about whether that's a good thing or not, but it is there, and I think it's interesting to look at it from this perspective. There are key issues with this extraterritorial reach and this idea that we're exporting values of the European Union. First of all, it is debatable whether this is ever efficient. To do that. Can we really, even the European Union, the economic powerhouse that it is, can it really influence what companies are doing in foreign countries? This is debatable. I think we can see it both ways. Secondly, compliance will be a huge challenge. I've written about this in Business and Society 2019 with regards to a different piece of legislation, but there's a real risk of what we can call the managerialization of law, whereby companies will make this directive, make this legislation their own and translate those human rights and environmental issues into language and practice that they know and are familiar with, perhaps losing in translation the, let's say, transformative goals of the directive. Compliance will be a huge challenge. I see it. An issue that I'm very interested in, we see that among the directive supporters right from the start, there was we could see a narrative of moralization, meaning that they would insist on the fact that it is the European Union's duty, its moral duty, to share its human rights and environmental achievements with the rest of the world, a narrative that you will be able to read about in a week or so. I just worked on the proofs in this piece that's forthcoming. So that's one way of presenting it, a narrative of moralization, exporting the good of the EU, but some have actually characterized due diligence law as neo-colonial. in nature, as in there's a fine line between exporting your values and actually imposing your values, or considering that you hold the truth. Since we are on the topic of those who have criticized the due diligence law, the due diligence directive, I will mention that the Chinese Chamber of Commerce has also reacted to the adoption of the directive and feared that it would create too much bureaucracy. So how much do I have? How long do I have, Chiara? Okay. All right, cool. Okay, so there is definitely an emerging body of literature on critical and third world approaches to international law, perspectives on due diligence legislation. I've put some examples here. I think there is more coming, but they all go into this issue of exporting EU values or exporting, let's say, global North countries' values, and just basically criticizing these types of legislation from that angle. So the second point I had was about the Brussels effect and the potential Brussels effect of this legislation. So as I said earlier in the timeline, we have adoption, hopefully in April, then transposition for a couple of years, then implementation, and then we can expect maybe the Brussels effect to occur. So what is the Brussels effect? As theorized by Professor Bradford, we have de facto effect, whereby we will see companies outside the European Union who change their policies, change their practices, to be able to keep their relationships with the companies that fall under the scope of the law. Yeah, so this idea that if you're a large company that falls within the purview of the law, you have to clean up your supply chains. Let's just put it that way. You have to make sure that human rights and environmental protection are there in the policies and practices, and so you will require those changes from your partners, and those partners will have to make those changes if they want to keep doing business with you. Yeah, so this idea that there is a de facto effect, that it will influence how other companies work, and we have Professor Bradford documented that effect in other areas, particularly in health and safety, where we've seen food safety, for example, for companies who want to be able to trade with large European companies in food, have to adopt a certain standard. And that in the end, because companies don't want to have two separate factory lines, they then have one, and that means that EU legislation has an impact beyond the EU. And we also see a potential de jure effect, meaning that in response to the Corporate Sustainability Due Diligence Directive, we could see third countries actually legislating to bring their also activities up to standard. And I recommend this article by my colleagues, Rachel Chambers and David Birchall, who have already published an article on how this legislation might reshape business law in the United States, because same idea that they will have to keep their business in the EU, they will have to somehow up their game when it comes to labor law in particular. That's the focus of the article, but similar. And then 30 seconds on the Business and Human Rights Treaty. We now have this directive. I keep saying we have it, we don't, but 24 April. So I think we're close. So the good news is that it shows that you can turn parts of a soft law instrument like the UN Guiding Principles on Business and Human Rights. It is possible to harden this soft law instrument, to turn it into binding legislations, even though we see that compromises are needed. We can perhaps expect a change in the EU's current lack of engagement in the Business and Human Rights Treaty negotiation, because for years they've said, we're working on our own thing, that's why we're not engaging. Well, now you have it, so can you please engage? Or at least that could be it. And of course, there is an issue of complementarity between the directive and the treaty. At the moment, the treaty goes much further, but it's not in place, whereas we have the directive. So you can see it as a glass half full situation. And then finally, this is our team, the Business, Human Rights and the Environment. research education at Wageningen University of Research. We publish books, we have great conferences, we win education prizes. And please get in touch if you're interested in those issues. We do receive guest PhDs. So Chiara Morfea was with us for a few months, and that's why I'm here. But please come and tell your students, and thank you very much.
Thank you very much, Nadia, for such an insightful presentation. Now we will open the floor for some questions, both from people online and here. You can stay here with me.
We had the presentation now. The next one. No.
No.
Okay, that's fine. No problem.
We can take questions online, and you can just unmute yourself and hear from the auditorium. Please raise your hand if you have some questions. Yes. Is there anyone here from the or online?
Maybe we can have joint.
Do you have it? Okay, Ignacio.
Is this working? Yes. Okay. First, thank you so much, Nadia. Welcome to Bergen. Wonderful presentation. Very interesting. My name is Ignacio Raranchustegui. I'm associate professor here at the law faculty. And you mentioned this issue of why are we not listing the international agreements, right?
Mm-hmm.
And asking this based on absolute pure ignorance, because this is not my field at all. I'm wondering, is it even needed? You're a state, you're bound by the international convention. Listing it is like what I would expect a master's student or myself when I'm writing a paper. Let me remind you what you have to do, but the state should be aware of their obligations, right? Or do you think that it might have a different impact? And I'm wondering, maybe the reason for this is that not all member states are part of the same conventions. Could that be one of the reasons?
Yeah, so can you hear me? Yeah, so to clarify, they list rights and they also list conventions. And to me, that makes no sense, because either you do one or the other. Anyway, so two things. Yes, I think not all countries have ratified the same things, though within the EU actually would need to look at this. I think indeed that's a master student's perhaps a project, but I think that kind of solves that issue, that everybody is on the same plane. But also, because the directive is meant to apply to foreign companies, then irrespective of what their country of nationality will have ratified, these will be the rights, like substantively, these are the rights that they will have to address. So that's the added value, if you will, of actually listing things, because if you just rely on countries, then the foreign companies, they wouldn't know what to do. So I guess it's to clarify. It's meant to clarify. It's not super clear, but it's meant to clarify, I think. Yeah.
Yeah. Is there some, Federica, you had a question? We can use.
Right. Yeah, there's this one as well, Federica.
Okay.
Yeah.
It should work.
Yes,
Okay. Thank you, Nadia. It was a wonderful presentation, super interesting, and I'm glad that there is a clear link between human rights and environmental due diligence and public procurement.
Mm-hmm.
We can discuss it later. I wanted to ask you whether, like, how far in the supply chain can we go with these due diligence obligations? Because this is relevant to public procurement in the sense that right now, we were talking about it with Chiara earlier, right now the responsibility we can claim is from the contractor to the subcontractor, and I think to the subcontractor. But I'm not sure, after the adoption of the Corporate Sustainability Directive, which my colleagues managed to demonstrate it applies also to public procurement, how far can we go in the supply chain?
Yeah, so this is a big issue. And this is where I don't know if it's the most difficult issue, but it's definitely one of the complicated issues, in that in the UN guiding principles, which is where it all started, if you will, you have very vague language. Yeah, identify in your operations, whatever that means. And so you have this sort of fuzzy concept of it's everywhere. It's all your suppliers of suppliers of suppliers. It's all the way. And of course, when you are, when you have a text that is soft law that is meant to establish some key ideas, it's okay to use that language. But when you have to legislate, that this becomes a massive issue. And for example, in Germany, in the due diligence law in Germany, they have stopped at the first tier. Yeah, and because they considered that they couldn't legislate in a way that would go further than that. So in the directive, I'm reading this as more than one tier.
Yeah.
But this is where implementation is going to be very interesting, because what if it's not possible? What happens if it turns out it's actually not possible? Is it possible? I don't know. I think there's a lot of companies, large EU companies, that are supportive of the directive and of the idea. So I'm going to go with the idea that it is possible if they support it. Because they never talked about first year. They always, they supported a broad text like this. But how will it actually work in practice? So the way that I think some companies want to deal with that is through contracts. So I contract my first year, and then the expectation is that they will contract out the obligation to, all the way. And there's language about this in the directive. There's actually model contractual clauses already that are circulating on this. That's one way to deal with it. Is that the way that a human rights lawyer will like this addressed? Probably not. But yeah, it's managing out the issue to through contracts. Yeah. So I don't know is the short answer.
There is Nadia Ulla online that raised the hand. Please unmute yourself, make the question.
Hello, can you hear me?
Yes.
Great, thank you for an interesting presentation. I'm Nadia Ulla, working for the Norwegian Consumer Authority. We supervise the Norwegian Transparency Act. You briefly mentioned that there are going to be some interesting discussions around the role of the supervisory authorities while implementing the CSDDD. I was wondering if you could give some more, do you have some more concrete ideas or thoughts around that? That would be appreciated. Thank you.
Yeah, thank you. I think so. I actually don't have the article in mind. I could put it in the chat once I have access to my phone. I will recheck. The text talks about how states have the obligation now to create this authority, or to empower an existing authority with that particular set of powers, and they're supposed to check implementation. Now, I think if you start thinking about this, and I'm sure you're aware of those issues considering where you work, what does that mean? How is business confidentiality going to be dealt with? I see about 1,000 issues with that. On the other hand, I think it is interesting because so far, the approach with due diligence has been ask companies to do it, hope for the best. If it doesn't work, there's always litigation. I don't think that's a serious way to address a problem when we know how difficult litigation is, how costly it is. This is not, this is not a solid plan, I would say. So I can't really answer this question, but what I do think is that it is really a novelty, and it's something that we don't have in any of the other due diligence legislation. It's not even envisaged in the guiding principles. So that's, I think, pretty cool.
Thank you. We have time for one more question. Is there? It's okay. Please unmute yourself online.
Yes, thank you very much for your presentation. I was just wondering if you could say a little bit more, what are your impressions on Article 15, that is the climate article, if you have any, because you mentioned that it's not very similar to the rest of the due diligence obligations. So I was just wondering what kind of obligation that would be. Thank you very much.
Yes, that's a good question. It's very fuzzy. That's what I can say. It talks about having again, the exact language now escapes me because I was focusing on the other provisions, but it is like companies are supposed to have a plan in place with regards to their climate impact, but it's very loose language. And it's not a hard obligation in the same way as the due diligence obligation. So for me, I think, yeah, it would require really a separate presentation, I think, to talk about this in itself. All I can say is that it's disappointing it's not in there as such, like it's not listed in the list of conventions. That's what I'm making of this. I think those working more specifically on climate will have perhaps more interesting things than me to say about this. Yeah, this is not really my my area.
Okay, thank you so much. Now we are gonna have, if there are no other questions, we are gonna have a 10 minutes break, and we will 5 minutes break, and and sorry, and we are gonna meet here again in 5 minutes for Federica's presentation. Thank you. Thank you so much, Nadia.
Thank you so much, Nadia. 5 minutes break. Ignacio's 5 minutes. That means 5 sharp minutes. Go get something to eat, and we will come back. And those of you online, get yourself a cup of coffee or tea or water, and then we will be right back. Thank you.
For this second part of the seminar, we are going to delve into green public procurement discourse. We are lucky to have Federica Muscaritoli, who is a PhD candidate from the University of Copenhagen. Her PhD fits into a larger project, the Sapiens Network, which is also a EU Horizon project. Federica holds a bachelor from the University of Rome La Sapienza on political science and international relations, and a master in European legal study from the University of Torino. Her PhD focused on public procurement as a tool for climate mitigation, and today we are gonna hear more about that. Federica, the floor is yours, so please go ahead.
Thank you very much. I'm very, very glad to be here, to have been invited. So a special thanks to Ignacio, to Chiara, and to Line for making this possible. I believe that at this stage of my PhD, I'm close to the end, is a really valuable occasion for me to get some feedback, to like test my public speaking again, and perhaps doing a good job for non-expert or not passionate people about public procurement, understandable. So this is the title of my PhD project. So public procurement as a tool for climate change mitigation. I am Federica, and thanks to the University of Bergen. So this is the agenda for today. We have a general introduction to public procurement for those people who are not familiar with it. Then I will define a bit more the thesis scope, and I will provide you with a pop version of my research question. So it is more like understandable and attractive, more sexy. Then we will go to green public procurement, which is a well-established concept, because perhaps some of you are asking, well, but we already have green public procurement. Why are we talking about climate change mitigation here? So then we will draw some insight from the historical evolution of the EU regulation of public procurement law. This constitutes a bit my theoretical framework. You will find out in the course of the presentation that there are some common criticalities in this aspect of including environmental consideration in procurement. So this chapter, this part of my thesis, is aimed at giving my point of view, of course, like well founded on like legal theories and principles. Then we will talk about, indeed, this very hot topic of sustainability and internal market. It seems like an endless struggle, endless topic, which is still debated, although I believe that we are sort of coming to a conclusion about this. It is not that controversial as it was before. And then we will talk about how we go from the green public procurement to low emissions public procurement. So public procurement is the process whereby state, regional, or local authorities seek to procure goods, services, and work to satisfy the general interest. It is regulated both at the national level and at the European level, actually also at the international level, but we are not gonna talk about it today. So procurement codes regulate it at the national level, and a package of 4 directives regulate at the European level. There are 5 generations of this directive, and we are at the 5th right now. So the objective principles, let's say, that guide the regulation of public procurement at the national level are efficiency, run the procedure in a smooth way without undue delays, integrity, preventing corruption during the procedure, value for money, getting the best quality for the lower price, and discretion, in my opinion. This is something I added, especially in the field of sustainability and using public procurement as a tool to achieve other objectives than the simple economical ones. Discretion is what remains to the member states in the European space to afford that freedom to pursue these secondary objectives through procurement. Is this regulated by the EU? Is this a freedom that member states enjoy? Where is the balance here? And then the objectives, which are already principles of public procurement at the EU level: equal treatment, non-discrimination, proportionality, transparency, and most importantly, at least for my thesis, sustainability and non-artificially narrowing competition. And I will explain them later. So public procurement is all around us. It is work, it is supplies, and it is services. Work can refer to projects like this, embedding nature-based solutions in a construction, or basically build a school for the simple sake of having a school without any sustainability requirements in it. It is the canteen service we have at the faculty is the service that provided us with the panini a few minutes ago, and is the cleaning service which allows this room to be like very clean for us and enjoy a nice conference like we are doing today. So procurement is a process, it's not a contract. Contract is what comes out of the procurement process. And this circle, which in my opinion should be more aligned, but this is what I found on Google, in my opinion is a line because it does not necessarily repeat itself like continuously, like an eternal return. So we have the procurement planning, understanding the needs of the contracting authority. We have the requirements definition, which is also called in our jargon technical specification. So we establish beforehand what are the mandatory characteristics of the good we want to buy, the good, the supplied service. And for example, we can require that the chairs we want to buy for the auditorium in the University of Bergen Faculty of Law are red. We are allowed to do this. What we are not allowed to do is to ask that they are produced in Norway, for example. Another part is the evaluation and selection. This is the part where I focus as a contracting authority, not so much on the characteristic of the object of the contract, rather on the behavior of the contractor, on the characteristics, on the experience. And then we have the contract award, which is preceded by the award phase, in which I give additional points for additional characteristics, which are therefore not mandatory but optional, and that constitute the premium for the best candidates, according to what the contracting authority considers being additional characteristics. So my thesis focus on does not focus on domestic legislation laid down by member states, but only on Directive 2014-24, the scope of which is services, goods, and works, and exclude remedies, it excludes concession and utilities. And then it focuses on climate change mitigation and not adaptation. What is the difference? Adaptation is all the measures that we adopt after a climate catastrophe has happened, and is mostly sort of infrastructural solution. And the reason why I decided not to focus on that is that there is already a lot of literature on managing crises and emergencies after for any reason, also climate reasons, and that because these kind of emergencies gives the possibility to uplift certain obligations contained in the public sector directive due to the emergency in course. Let's imagine like an earthquake and we have the ruins in the city. We don't have the time to run a very long procurement procedure. We run a shortened procurement procedure and we derogate on the famous principle of competition. So having as much supplier as possible due to the urgency. Mitigation is in my thesis intended as reducing consistently, perhaps, the amount of CO2 emissions or equivalent emissions. So what does European public procurement law has to do with climate change mitigation? Nothing. That's why my thesis exists. But this is only partially true, in the sense that just nerds like me differentiate or see different things between environmental law and the European climate change law. But yeah, this is the focus of my thesis. That's why I need to differentiate and understanding already existing concepts are enough for ensuring climate change mitigation. So, as I told you, we are not new to the inclusion of environmental considerations in public procurement. And indeed, we often talk about green public procurement as the intersection between economic consideration and environmental protection consideration. And we can say that low emissions public procurement is a narrow concept contained under the umbrella concept of green public procurement, which we can locate almost there. Green public procurement has been defined later in 2008 by the European Commission as a process whereby public authorities seek to procure goods with a reduced environmental impact throughout their life cycle when compared to goods and services and works with the same primary function that would otherwise be procured. And for me, this definition is problematic for the goal I want to achieve, so reduction of emissions. How much is the reduction? We do not say. And also linked to this, throughout their life cycle, the life cycle is a set of different stages, and they do not say whether we need to reduce emissions consistently for every stage of the life cycle or only for one. We can reduce the emissions of 1 kilo of CO2 emissions, basically nothing, and still this contract, this award procedure can be still considered green. But this is not consistent at all. And most of all, it is a policy statement. What is said here is not rooted in the law, is not reflected in requirements that are in the directive 2014-24. So what are we gonna do with this? The historical evolution of public procurement legislation at the EU level tells us something about environmental protection. We start in the 60s, establishing European Union rules on public procurement to abolish tariff and non-tariff barriers, and procurement was considered one of these. And along these 30 years, from 60 to 90s, the directive were sort of ameliorated continuously. Then we got to a point in the 90s when the Single European Act was adopted for amending also the European treaties, that the Commission pushed a lot for the environmental agenda and provided very detailed guidance on how to interpret the current legislation adopted at the time in order to include environmental consideration, still not mandatory. In the beginning of the 2000s, we have another reform of public procurement, adopting the 2004 package of directive. And they include, finally, in the legislation and not in Commission communication, still voluntary inclusion of environmental consideration, until we get here. The reform of PP in 2014 not only copy-paste the same environmental consideration, which are still not mandatory, but for the sake of clarity, with the exclusion of one, we have the possibility as a contracting authority, no, actually not the possibility, the obligation as a contracting authority, when we receive an abnormally low offer, to verify whether this is caused by violation of environmental, social, or labor law, and at that point, we are obliged to reject. But all the other references to environmental protection are not mandatory yet. I will not dig this much into it, but just for giving you a kind of example, this is like the most important outline of the case law concerning green public procurement. In these first two cases, they wanted to employ long-term unemployed. This is an example of how we can use instrumentally public procurement. Concordia Bus, in the award criteria, so that part of the procedure for giving additional points, they were valuing the noise levels and the nitrogen oxygen levels of the public bus fleet for the city of Helsinki, for example. So, is sustainability a nemesis of competition? I don't know you, so I don't know how much you are familiar with this, but this has been the strongest debate in public procurement for reaching sustainability goals. So right now, in the last version of the directive, we have this famous competition principle. Competition principle has been defined has been considered as such, as existing, even before it was embedded in the legislation. Professor Albert Sanchez-Graels said that this principle existed even before it was embedded in the law indeed. But now we have the court who said it exists, a principle of competition. So we cannot run out of it. But what are the implications? So some people believe that competition intended in procurement as having the highest number possible of economic operators participating to a procedure should limit the possibility of including other considerations that purely economical ones, because it can reduce a lot the amount of candidates. And my argument, a political one, is that, but we will never transition to a market of green products if we do not restrict temporarily competition. Now I don't want to rely anymore on this. Now for me, there is the law that says that I can do this. Because the law does not say we cannot reduce competition. And how much is reducing? How much is the minimum number of candidates participating? We cannot artificially narrowing competition when there is an intention of narrowing competition. And for me, unduly favoring or disadvantaging is just as, like the main scholar in public procurement says, is just an expression of other principles already enshrined in the directive. Unduly favoring means giving a different treatment to candidates. Disadvantaging also is disadvantaging through discrimination, disadvantages to a breach of equal treatment. So for me, competition is this. If it is intentional and artificially narrowed, which is basically the same thing. And what does the sustainability principle says? And do they really have something for which they overlap and they clash? In my opinion, not that much. So, according to the sustainability principle, member states shall take appropriate measures to ensure that in the performance of public contracts, economic operators comply with applicable obligation in the field of environmental, social, and labor law, establishing union law, national law, collective agreements, and international law. Good. But then, although it's not mentioned in the corporate sustainability due diligence, for example, then there is a social labor law, like it is very blurred what these categories of laws are. In the Annex 10, we have just 4 international agreements of the ILO, so that is not to be considered as exclusive. And my study, together with other people before me, demonstrate that first, member states does not refer just to member states as the national administration, but also to like lower levels of public procurers. The performance of the contract, which might be intended as the post-award phase, so the phase in which the contract already exists and the economic operators perform it, is actually not to be intended in this way, so narrowly, but it extends also to the procedure. And at this point, my question is, But well, what are the implications of union environmental law for the procurement procedure? So as a further demonstration that this principle of competition and the other principles should not restrict our engagement with the environmental consideration, in Concordia Bus, which is kind of an old case in 2002, the court said the fact that the award criteria referring to low noise and nitrogen oxide levels can be fulfilled only by a small number of undertakings, in this case were 2, perhaps getting to the award phase, it is not itself such as to constitute a breach of the principle of equal treatment. What is the relevance, and now we switch to climate change, what is the relevance of this research after I gave you the theoretical framework? So most importantly, we adopted in 2050 a binding target of reducing emissions by 2050. And in recital 25 of that law, the legislator said that all relevant union legislation and policies need to be consistent with and contribute to the fulfillment of the climate neutrality objective. This means that for the next law we are gonna draw, we should ensure that we are in line with this, I presume. Is a recital, so still bears like low legal importance, but still is something. And then we detect a paradigm shift. If before we were talking about a few references to environmental consideration, non-mandatory within the directive, now we have a lot, and I'm going to show you later, a lot of secondary legislation of the EU law referring to other aspects of environmental protection, embedding all of them, almost all of them, a provision referring to green public procurement and establishing requirements most of the time. So now we use public procurement as an enforcement tool for public procurement. And this doesn't seem no more as a discretion afforded to member states to pursue their own environmental, social policies, but it's a mandate of the European Union, perhaps reinforced by the adoption of the EU climate law. How to define low emissions public procurement then? I think we have 3-4 ways. We have an interdisciplinary approach, so we mix the law with climate sciences, and at that point we can say a lot of very nice things, very effective, but not rooted in the law. We can say that is, we can analyze the interlink between EU climate mitigation and EU public procurement law, or EU environmental law, which is kind of different, and EU public procurement law, which has indirect positive effects on CO2 and CO2 emissions, for CO2 equivalent emissions. For example, one law of the European Union considered environmental law and not climate change law is the deforestation regulation, allowing that deforestation is not a process as allowed as it is now, reduce environmental emissions because we maintain all the forests in Amazonia or I don't know where. And then we always have the help of the treaties. And the approach that I decided to have is this one: EU environmental law plus EU treaties. And why? No, not now. So the first approach, as I said, is the mix between public procurement and climate sciences. And I wrote a paper with my supervisor, Marta Andov, and we decided to try to give a definition of what could be an ideal, an optimal definition of low emissions public procurement. So its primary objective must be contributed to climate mitigation. It should adopt a life cycle costing methodology, which is a methodology to quantify emissions along all the stages of production and usage and end of life of the product, and requires the quantification and reporting of this emission quantification derived from the purchase, so that all this famous phantomatic quantification and reduce our emissions by 2030 by 50% is finally quantified, because otherwise we're just lost. Why I didn't choose the approach climate law and public procurement? Because these, for example, 3 legislation of the European Union, which are commonly considered climate mitigation law, bear absolutely no reference to procurement. And so this was kind of complicated. So I opted for the third approach, which is environmental law and public procurement law, including the help of the treaties. what do the treaties says? So we have the well-known Article 11. The supervisor of Chiara bridged like wonderfully public procurement and the environmental provisions in the treaties in a book that they published around 2009. And this article, which is called the Sustainability Principle of the treaties, says that environmental protection requirements must be integrated into the definition and implementation of the union policies and activities. And in the way I interpreted this provision in my thesis, requirements must be integrated. I don't think it needs a lot of explanation. Requirements are obligation, must be integrated is an obligation incumbent on the legislator. Policies and activities can include the lawmaking. So, and this makes sense if we look also at the interpretation of this article in light of another provision of the treaty, which is an umbrella provision to Article 11, which is Article 7. Article 7 is the cap, is the umbrella covering all the principles and objectives of the European Union enshrined in the treaties, and says that the Union shall ensure consistency between its policies and activities, again, taking all of its objectives into account. And if until a few months ago, this for me was finally the ground to say, amazing, we need to adopt, we need to give importance to the environment as much as we give to competition. Now, I mean, I don't do anymore for the reason I explained you before. The legislation on public procurement takes into account the same things. And the way we need to balance these things is not defined by the single contracting authority or by the national legislator implementing the legislation. It's decided by the European Union adopting the laws that now we have. Other provisions that I'm gonna analyze within my thesis, but I'm still on the planning, is, for example, Article 191, which is the main article in the Title 10 or 20 of the treaty, including some of the main environmental law principles. Does the polluter pays principle, for example, apply to public procurement? Nowhere is said that it doesn't, but if we want to say that it does, what are the implications and how can we demonstrate that it does? What about the precautionary principle, which is like more referring to the emergency procurement that we were talking about before? So preventing the effects of climate change, acting in advance. And when I talk about EU sectoral legislation, and we are close to an end, we talk about, for example, all this legislation listed here. The way I'm gonna get through in my thesis is that before the mapping exercise of finding all this legislation, which refer directly or indirectly to procurement or to procurement possible products, is that we see a trend. The trend is that, for example, Clean Vehicles Directive, Construction Product Regulation, which is still a proposal, and Energy Efficiency Directive mandate in the provision related to public procurement what we need to buy and the characteristics that these things need to have. Minimum target, hard. This is going to be very hard to implement, at least to the same extent of the corporate sustainability due diligence. Because what does it mean? We need to buy 20% of the national public transport vehicle need to be electric. Wow, okay, if I buy tomorrow other 10, then this percentage already changes. So it is very hard to implement targets into the law, and this is going to be very interesting for me to do. Then award criteria, the Net Zero Industry Act, which is going to be a regulation and now is a proposal, provides that we have to consider for maximum 20% sustainability aspects within the award phase of the contracts. And then we have a penalty of exclusion, which is the one I started to analyze. So basically, as I told you, there is a part of the procurement procedure when we evaluate not the object of the contract, but the provider of this object, the economic operator. And there is a penalty of exclusion in case of violation of, I don't know, like international mandatory regulation for avoiding child labor. Some of them are mandatory, some of them are discretionary and can be made mandatory in the national legislation. Well, the deforestation regulation does not only foresee that for a contract which might be in a totally different sector than deforestation related products. Sorry, it foresees that although the contract might be in a different sector, we must exclude an economic operators found liable for a violation of the deforestation regulation, and not only an exclusion from the procedure where it was found liable, but from the whole European Union, regardless of whether the legislation of the European Union applies or not. So above the threshold and beyond the threshold for which it applies. And I think we are close to that. We reached the end. This was my work so far. I hope it was not super rushed, and that you enjoyed. Although you are not familiar with this and you were here mostly for human rights stuff.
Thank you so much, Federica. It was wonderful and well presented. We open now the floor for questions as before. So if there are questions from the public online, just unmute yourself. And if there are questions here in the auditorium, just raise your hand. Yes, Sigrid.
Hello, yes, thank you. This was very interesting and very well presented. Just a short question on the principles you have chosen. Have you thought about the no harm principle and also the prevention principle as more kind of overarching maybe from the precautionary and polluter pays principle?
I did. It was not included in that list just to maintain a clarity of the slide without overburdening with words, but I did, and yeah, it's gonna be a lot of stuff in there. But yeah, I hope I'll make it. You mentioned that not causing harm, not. Yeah. I will include them. Yes.
Do you have a question also from? Okay, we take the one online. Federica, please unmute yourself.
Okay, can you hear me?
Yes.
Okay, thank you for your presentation. It was very interesting. I wanted to ask something which is also related to the previous presentation, that is, can the Corporate Sustainability Due Diligence Directive play a role in public procurement, or is it more focused on the private sector?
Can I answer?
Yeah.
Okay. No, as I said before, it applies to public procurement. I recommend you. I can send it to you, the references in the chat. There is a recent published paper by two colleagues of mine regarding exactly this, demonstrating the link between the Corporate Sustainability Directive and public procurement. The only problem of applying, I mean, at least for me, because in the paper you will find everything better explained. The only problem I find is that establishing what is the threshold, how back in the supply chain should we go to verify violations, because almost for every product we can find violation along the supply chains, and at this point we cannot ensure that the general interest of the citizens is met if we at the end cannot provide goods, because along the very long supply chain of certain products there are violations of human rights or environmental legislation.
Nadia, you can. Yeah, I can just.
Yeah. Yeah, thank you. This is really interesting. Very, very interesting. I wonder, this is more like a methods question. So I wonder, how do you mentioned this language that is a bit fuzzy, so narrower, but how much narrower? Fewer emissions, how much fewer? I wonder, how do you deal with the quantitative aspect, if at all? How do you deal with the quantitative aspect of your research? Is there any sort of interdisciplinary research, maybe not you, but that is done in this area? Because at the end of the day, I feel that it's very difficult then to evaluate efficiency unless you actually can quantify this, also to sell it to others and to make people really aware and understand like the impact of this. So yeah, I wonder how you deal with numbers basically in your research or
So honestly, the way I deal with numbers is that I decided to give optimal definition of public procurement for climate change mitigation. And then I decided I'm not going to do the legge ferenda because this was like too muddy floor. And I wanted to do the legge lata. There was a lot of new legislation, which you saw in the last table. And I was like, the legge ferenda, I'm not experienced enough with the environmental sciences. I might do something which is heavily criticized. I would prefer to do something which is going to be still heavily criticized, but that my supervisor is more familiar with, which is dogmatic. So there are if I have to tell you what is the main weakness of merging these two disciplines, so public procurement law and climate sciences, as far as I saw, is that people who write these articles or these reports are not very knowledgeable of the nitty-gritty requirements of public procurement, which like the court created, blah, blah. And so at the end, we have a lot of reports which are useful and very well written, but at the same time, the lawyers are there saying, this is not doable, this is like illegitimate, this is not permitted by the law. So, yeah.
Ignacio, you had a question?
Yes, thank you, Federica. Very nice presentation, very thought-provoking and interesting on what you're working with. This is not a question, it's more a comment and a suggestion for you. Just thinking about it, and maybe some of my colleagues will say about it. So the comment is more for everybody. Federica is talking on a topic that is super important in Norway. We have a law now that says that for every public purchase, this is offentlig anskaffelse, 20% of the award criteria, it's going to be sustainability. So we see this already in Norway, requirement by the law stated, unless am I wrong? Am I wrong, Linda? No. 30%. You see, I'm so outdated. It's even more. So we are seeing this being pushed as a policy objective. So you are already riding on the wave of this. And a comment that it is connected to the 20%, it's that we are seeing this also in something that you're not dealing in your thesis, but is very much connected. So it's how the state is purchasing renewable energy, which is what I work with. So in the current bidding that we have for the wind parks in Norway, we will have one bid that is for an area that's called Utsira Nord. And in that bid for building of a wind park, there is already baked in the bidding documents 20% criteria. It's supposed to be how sustainable the project is. So it is how sustainable is an energy sustainable renewable project. So it's like a double whammy. But very interesting too, because you're seeing that, okay, it's not public procurement, but it's the reverse. So public procurement, I think you have a very good point. Sustainability and procurement are coming in together and connected to the issue of competition. You know as well probably about the big shift that is taking now on competition, taking into account sustainability, and in particular sustainability agreements and what it means too. So we're seeing now in a way that the climate emergency is that strong that this is being pushed from all the angles. And just to give you that maybe a bit of Norwegian flavor, because those 20% numbers and 30% on public procurement are very telling. This is requirements by the state when you're entrusting to do some building or buying something directly.
Thank you. Is there any other questions in the audience here online? If not, I will abuse my position of chair. You've mentioned in the last slides that the deforestation regulation might play a role in terms of public procurement for climate mitigation, and is something you are looking into or you will look. Can you tell me a bit more about the role of this deforestation regulation in terms of climate mitigation and public procurement? Thank you.
Yeah, we just wrote about this. So so it's very interesting, like the deforestation regulation represents an example of these sustainability mandatory requirements related to procurement, but inserted in EU environmental laws. And in particular, there is Article 25 of the EU Deforestation Regulation, which establishes a penalty of for public procurement, saying that if you, as an economic operator, operator and trader, are in violation of the deforestation regulation, you must be excluded, among other penalties, you must be excluded from a procurement procedure for a maximum period of 12 months. And this maximum period is within 12 months is decided by a final judgment by the judge. But what is interesting is that, and also here we have a corporate sustainability due diligence problem, human rights and environmental sustainability due diligence problems, is that the verification as to whether we comply, we are respecting the deforestation-free regulation is very hard. Because basically what the deforestation regulation says is that we cannot import in Europe or export from Europe raw materials or products derived from this closed list of raw materials if they cause deforestation along the supply chain. And among these products, there is coffee, there is wood, there is soya, there is cattle. So very like goods of a very wide usage, you know, and all the products like deriving from that. So if tomorrow they find out they renew the canteen service for this university, and that person is the same that provides coffee in our kitchen close to our offices, and that coffee caused deforestation, we can terminate the contract, basically, you know. So these are the potential implications, which I'm not saying. I agree with Nadia, and this is more like an opinion I would like to give. It is a new colonialism of laws. And also we are disregarding, I also say this, we are privileged to be able to make all this environmental and climate law legislation. We are like the Europe, we are rich, we are a union, we are strong. But at the same time, this is gonna positively impact the environment if we properly implement it, but also be very, very detrimental to local communities who perhaps do not even know that deforestation is negative, or do not know of the big impact that which is creating like elsewhere. So I don't want to, I would like to mention that it, at least from my ideological perspective, I don't fully agree with this whole thing, although I must be happy at the same time that Europe is becoming more sustainable.
Yeah. Okay. Yeah. In the end, it's always about sharing the burden of how we're gonna transition to sustainability and rebalance this privilege system. Yeah. Thank you so much.
Thank you.
And if there are no other questions from the audience, I want to thank you everyone for attending online and here, and Ignacio and Line for the help in organizing this event, and our two special guests. Okay.
Yes. 1 second to everybody. I would like to say thank you so very much to Chiara and to Lina that are here for making this fantastic webinar and seminar here in Bergen possible. Wonderful to see promising PhD candidates taking the stand. This is not so easy as you think. We have to run and make sure that everything is working. The food is out there. The internet is working well. And both Line and Chiara have done spectacularly. So on behalf of the University of Bergen, tusen tack. Grazie mille. And to those of you joining online, you know, we have this typical events about every 3 weeks. Join us. You're very welcome. You're very welcome to come to the University of Bergen as well. For those of you in the room, I would like to ask you to come to the front so we can take a picture. So the ladies and the two gentlemen, I'll take the picture here. We have a very feminine crowd, which is very nice to see also in academia, women taking over the world. So we'll do that. And those of you at home, thank you so very much. Have a wonderful weekend, and we will send around the slides and the recording. Thank you.
Bye. Thank you.